What are neighboring rights? There are two main copyrights to be distinguished in the music industry. The composition copyright addresses lyrics, music, and melody. The master sound recording copyright is associated with the actual recording of the song. Neighboring rights is a term that relates to the royalties earned from the public performance of a sound recording. The performing artists on the recording and the copyright holder of the master recording are entitled to receive royalties every time it is broadcast on TV, radio, or any other live performance. In essence, neighboring royalties for performing artists and master owners are the same as the performance royalties are for songwriters and publishers. Remember from our previous videos that US performance royalty organizations collect and distribute performance royalties for songwriters and publishers, but not for performing artists and master owners, most often record labels. In the United States, neighboring rights are not recognized. US broadcasters are exempt from paying license fees for performers and labels when sound recordings are performed on terrestrial radio or TV. As a consequence, the United States does not have a traditional collection society for the collection and distribution of neighboring rights royalties. The closest thing to neighboring rights in the US are the digital performance royalties collected by Soundexchange for digital transmissions only. So why doesn't the US have a society that collects and distributes neighboring royalties? The answer goes back to 1961 and the Rome Convention for the Protection of Performers, Producers of Phonograms, and Broadcasting Organizations. Only countries who are signatories to this convention recognize and pay neighboring rights, and only performers who are permanent residents of one of these countries, or if the musical recording was made in one of the countries who signed the Rome Convention, are eligible to receive these royalties. And you guessed it, the US was not one of them. There are various reasons why the US did not become an initial signatory to the Rome Convention Treaty. One suggested justification is that radio station lobbyists feared that terrestrial radio stations would then have to pay additional license fees, essentially doubling its current fees. This additional expense would have resulted in a severe strain on their business. The US's refusal to recognize neighboring rights has created a ripple effect that hurts artists where they can least afford to be hurt today, their wallets. For example, you're a US-based performer who recorded your song in the US. This song gets publicly performed in the UK, one of the initial signatories of the Rome Convention, where neighboring rights royalties are paid. But you ain't getting it. Why? Because think about it in reverse. A UK-based performer records a song in the UK and it gets played in the US, like maybe the Beatles. And the US doesn't pay neighboring royalties, so the countries that do pay them figure, why should we pay your artists if you don't pay ours? While the reciprocity issue is understandable, it begs the question, where's the money? Remember, this money is paid by the broadcasters in the signatories' countries via a blanket license fee, in the same way the broadcasters in the US pay a blanket license fee for public performance rights of the compositions in the US. It's just that it's not distributed to the performers and labels from the US. Therefore, it sits. And after a while, it goes into the void of black box royalties. The only way around this right now is for US labels and performers to record in a signatory country. Anyway, neighboring rights remain untapped as revenue streams for many featured US musicians and master sound recording owners. Is your music played outside of the US? Are you missing out on neighboring royalties? Let us know in the comments below after you click the subscribe button and notification bell.